Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
Of the nation state called Ghana. If nothing is done about Galamsey, this country will collapse. That is what we are talking about. Now, my second point is this. There are some people from the New Patriotic Party and so on who have come forward and said, look, Wuntumi was not engaged in Galamsey. He was not doing illegal mining. Who can disagree with them? Who can disagree with them? If you look at the charges preferred against Wuntumi, it did not say that Wuntumi was engaged in illegal mining. It didn't say so. What it said was that a mining concession that he had acquired lawfully had been reassigned to a third party who was engaged in illegal mining. That's the charge. So, to criticize the judgment on the assumption that he was not engaged in illegal mining is neither here nor there. Nobody charged him for personally engaging in illegal mining. That has to be understood. Now, the person to whom he gave permission to enter his concession gave evidence before the court. He says, yes, I got the concession. I was doing illegal mining, and I was doing it in order to generate resources to pay myself. Wuntumi had given me some job to do, and he didn't pay me. And he said that I should do this kind of mining to generate resources to pay myself. You understand? So that's also very, very clear. So it is not true that Wuntumi did not personally benefit from the illegal mining. You understand what I'm saying? Because he was supposed to pay the contractor he had hired to do reclamation on the land. The money he's supposed to have paid that contractor for doing reclamation, he kept for himself, according to the evidence before the judge, before the High Court. Clear? You understand? Then, one of the arguments is that, well, he is a political prisoner. And by Jove, I heard a leading member of the New Patriotic Party explain why Wuntumi is a political prisoner. And I almost collapsed. Leading member, a very respectable member of the New Patriotic Party. And this is the argument he put out. He said, Wuntumi is the regional chairman of the New Patriotic Party in the party's stronghold. And therefore, his trial is political.
He's a political prisoner.
Hey, Master, where is this coming from? I thought that the dictum of the law is that the law is no respecter of persons. Now, we are saying that if you become regional chairman of a party in the party stronghold, you are above the law. Nobody can touch you. If they touch you, no, you are a political prisoner. Hey, yo. Master, I mean, when I heard this argument, I said, my goodness, where is this argument coming from? Then I heard another argument, very interesting. And the argument simply said that, look, the prosecutor in the case was the Attorney General. That the Attorney General is actually a member of President Mahama's cabinet and a member of the National Democratic Congress. And therefore, if the Attorney General prosecutes a case, it is a political case.
Yeah. Yes.
I said, let's do some extensions here. So when the Attorney General prosecuted Atai, it became a political case. So when the Attorney General prosecutes anybody, it's a political case. It simply means that the Attorney General, nobody can be prosecuted in Ghana. Because if you read the 1992 Constitution, and today I brought the Constitution to the studio. I think it's the first time
You're doing
so.
that, yes.
But I brought the Constitution to the studio. Article 88 of the 1992 Constitution says, is headed the Attorney General. And it says, Article 1, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to government. 2, the Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. 3, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offences. The rest of the provisions don't matter. So, the argument which is actually being made by some of the people in the NPP is that all convictions are political. All the armed robbers in prison, they are political prisoners. Hey, unbelievable. But they are making this argument. Okay? Then they go on to make other interesting arguments. And one of the arguments they make, which I understand is going to become the basis of the case they are taking to the Court of Appeal, is that lawyers of Chairman Wuntumi at a certain point in the trial asked that some law should be referred to the Supreme Court for interpretation, and the court did not allow it. Let me say again that I'm not a lawyer, but I read a bit, you understand, and I've read judgments of the Supreme Court. I've read Lord Denning and others. And indeed, they insist that the true position of the law is that a judge at a lower court may only make reference to the Supreme Court for interpretation if the judge himself or herself thinks that there is need for interpretation. But if the judge understands the provisions of the law and understands that there's no controversy, the judge has no obligation in making reference to the Supreme Court for interpretation. This is the position of the law. And these big lawyers in NPP, they don't know that. I mean, it's incredible. They don't know that. So, I have read this judgment. It's 50-something pages. And I'm taking my time to read the judgment. Again, let me repeat that I'm not a lawyer. But when I read this judgment, I was highly educated. And indeed, I think that this is one of the best judgments ever to be written. I was so impressed, with the judgment as pronounced and so on. But Sana, those of us who claim to be defenders of the rule of law and who claim to uphold the rights of citizens and so on, must learn one thing which is so very important. Senna, the judges are also Ghanaians. The judges have rights, like all of us. And we cannot, in the process of pretending to be defending our rights, blatantly violate the rights of judges and destroy their reputations for nothing, for no good cause. Because to say that this judgment is politically tainted is to accuse the judge of being politically manipulated. And if a judge is politically manipulated, it's a huge indictment on the judge. You destroy the reputation of a judge when you claim that the judge is politically manipulated, especially when you have no evidence whatsoever to suggest that. You understand? So, in defending the interest of Wuntumi, in pretending to be defending the interest of Wuntumi and so on, they are at the same time doing irreparable damage to the professional credibility of a woman who has risen to become High Court judge. And I cringe. What has she done? Just doing her job. It is possible that perhaps her understanding of the law is not correct. It is possible that she has made mistakes in the interpretation of the law and so on. Say so. Go to the Court of Appeal and get that decision reversed. Don't destroy an innocent woman. Because what they're doing amounts to the destruction of an innocent woman. You understand? To the extent that some of the commentators from the New Patriotic Party are referring to her ethnicity. What a shame! What a shame! We can't get out of tribal politics. They are referring to the ethnicity of the judge. How dare you do that? How dare you do that? What is the basis for that? And so on. Now, 2 days ago, there was a spectacle. Real spectacle on the road to Sao. What? Come and see Land Cruiser. Land Cruiser be what? Land Cruiser, Land Cruiser, Land Cruiser. With their headlights on, sirens blaring. Going to the Sao prisons for Dr. Mahmoud Bawumia to pay a courtesy. Some children are so deformed that they would never be able to function again. Never be able to function. The reports we are getting indicate that if you go to Obuasi, and Obuasi used to have the sweetest oranges in Ghana. Sweetest. In fact, if you cut the oranges open, the inside is yellowish. Very, very sweet. The reports we're getting is that if you go to Obuasi today, the food in Obuasi, cassava, cocoyam, plantain, and so on, has arsenic levels which are 10 times more than what the World Health Organization has approved. The food has become poisonous. If you eat it, you harm your body. We have come to a stage where water, we have found exceedingly difficult to treat water for consumption in our communities. The impurities in our water is so much that the cost of purifying water for consumption has jumped through the skies. Indeed, in some places, water treatment plants have had to be shut because you can't do anything about that water. The quality is so bad that you cannot treat it. Master, national infrastructure is collapsing before our eyes. And I've seen videos of bridges which have collapsed simply because Galamseyers went under the bridges to dig, and the bridges have collapsed. Roads have become immotorable as a result of the operations of illegal miners. So the havoc we are dealing with is huge, is humongous. I mean, there's a community somewhere in the eastern region where the illegal miners actually dug under the community to the extent that a pregnant woman who was going to take her bath innocently, because the ground looks normal and so on, fell into a deep ditch and she died. Because underneath the structures, underneath the bathroom, underneath their bedrooms and so on, the illegal miners had dug huge holes and people are dying. You understand? Last year, cocoa production came down more than 50%. Cocoa production. So when all kinds of people were throwing punches at Randy Abe and so on, they forgot to mention that cocoa production had gone down by more than 50%, largely as a result of the operations of illegal miners. Cocoa trees are being cut. You understand? Cocoa trees are being deliberately cut in order to facilitate illegal mining. Yes, I agree with my brother Adakwa that illegal mining is not just carried out by small-scale persons. So sometimes even the multinational corporations are engaged in illegal mining. Our fish stock is getting depleted and so on. This is what we are talking about. We are talking about the survivor. The argument which kills me, I mean the one that kills me completely, is the argument that President John Dramani Mahama has set up a constitutional review committee. And that the constitutional review committee has proposed that we should take out tribunals from the 1992 constitution. And because of that, we should not have tribunals. First and foremost, the report of the Constitutional Review Committee set up by President Dramani Mahama is not law. It is not law. It cannot be law. It's just a recommendation by a presidential committee. It doesn't have the effect of law. Now we are saying that we should ignore the laws and instead implement the report of a presidential committee. Hey, babe! How? So can you believe this? The lawyers, former vice president, are making the argument, brazenly standing in front of cameras, holding press conferences and saying that there's a report of a presidential committee which is more important than the constitution. Abba. I can't believe it. And they do so with smiles on their face, with courage and so on. They look the 35 million people of Ghana in the face and say that the report of a presidential committee has more weight than the constitution, which was promulgated through a national referendum. What is happening? what is happening in Ghana. Unbelievable. But that is their position. You know, and then they go on to say other things. This matter went before Parliament. It went before Parliament. Ally? The majority and the minority discussed this at committee level. They haggled over it and so on. It came before the plenary in Parliament. They haggled over it there and so on. They voted on it. It went to the president for assent. The president has not assented it yet. And then a presidential candidate holds a live broadcast and tells the president, wait, don't sign it. Come, let's have discussions on it before you sign. I'm wondering, what is happening? The NPP has more than 80-something members of parliament. Are we saying that the NPP parliamentarians, when they go to parliament to discuss bills and so on, they do so on their own without consultation with their party structures? That they don't represent their party? That they don't represent their constituents and so on? So when they have gone and taken part in debates and have arrived and Parliament has arrived at conclusions, we now stop, take the issue back to the NPP and perhaps to their constituents for discussion before assent. Senna, to be honest with you, some of us are getting tired. I mean, we are getting tired. Senna, to be honest, we don't just get confused, we get tired. We are wearing down. This is what in English language sometimes is described as shenanigans. Is that the word?
Shenanigans.
Sometimes. Because your members of parliament, over a period, were discussing this matter, and you had something to say, and you didn't call them to tell them what you thought so that they could represent your party and their constituents properly. You waited until the bill has been passed, and then you have live broadcast calling on President Mahama to wait and come for conversations before. Incredible. In any case, parliamentary procedure, as I know, when these matters are being considered, members of the public have a right and a duty to make representations to Parliament. Were you sleeping? Were you sleeping when the process was going through? I cannot believe it. So today, these chaps are calling on President John Dramani Mahama to actually ignore provisions of the Constitution, not to respect Article 142 of the Constitution, to act against the Constitution. Let us say that President Mahama agrees to do as they want. What if next week President Mahama also then decides that, well, there's a precedent? We actually ignore provisions of sections of the Constitution, and that I'm also going to ignore Article 270 of the Constitution. What moral authority would we have to hold him to account? You understand? If we encourage President Mahama to violate any section of the Constitution, would we have a moral authority to prevent him from violating other sections of the Constitution? This Constitution is either wholly kept or wholly thrown into the dustbin. Article 142 is part of the Constitution. Now, what is also interesting is the fact that in Ghana, there is a hierarchy of laws. Hierarchy of laws. The supreme law of Ghana is the 1992 Constitution. And indeed, all other laws, including laws passed by Parliament, including laws which are established by President in the court and so on, are subordinate to this law. You understand what I mean? Are subordinate to this law, which is the fundamental law. Now, some of us, for reasons which are difficult to fathom, are saying that, no, the Constitution is no longer the fundamental law of the land. And that a committee report should take precedent over the Constitution. Hey, my friend, what is happening? Can you understand? I can't. Many other issues have been raised. You see, the defect of the tribunal system established in the 1980s by the Rawlings regime was simply the fact that the system was not independent of the executive. It was under the thumb of the executive. It was fully controlled by the executive through how its members were appointed. That was a serious defect, and I agree. In the 1980s, if you were not a Rawlings loyalist or a PNDC loyalist, there was no way you could become chairman or member of a tribunal. That has been cured by the 1992 Constitution. Cured. Okay? So it is not the president today who is going to appoint members of the NDC to populate the tribunal. Now, members of the tribunal are going to be appointed the same way the Chief Justice empanels all other courts. So if you are not happy with the Chief Justice empaneling all other courts, it will not become a defect of the tribunals, but it will become a defect of the High Court, a defect of the Court of Appeal, and even by extension, a defect of the Supreme Court of Ghana. You understand what I'm saying? Now, the other interesting thing in Article 142 is that the Constitution says very clearly that you cannot be chairman of a tribunal if you are not qualified to be appointed as a High Court judge. So in terms of quality, the High Court judges would have the same quality as the chairpersons of tribunals. What is your problem? What is your problem? Decisions taken by the tribunals can be appealed against. What is your trouble? Then it says the tribunal may have at least 2 lay persons. Not exactly. 2 persons who may be lawyers. You say you don't understand. The traditional court system makes room for jurors who are not necessarily lawyers, who are lay persons. Sometimes they are teachers, sometimes they are priests, and so on. The traditional court system itself admits that. What is your problem? You see, I'm not a lawyer. I've never gone to law school. The closest I've come to the practice of law is to be some court reporter in the courtrooms and so on. You understand? Now, I do know that in some cases like murder, the trial of murder and so on, there's a process called assizes. I hope I'm getting it right. Assizes. Who determines whether a prima facie case has been established for the case to continue? Lay persons. So, look, I'm completely baffled. And what also shocks me is that all throughout my life, and I mean throughout my life, since I got to the position where I could understand conversations I could read newspapers and so on. One of the things that I've known about the new patriotic party and its history and so on is that they have always claimed to be a party of lawyers. A party which insists on the rule of law. A party, and this is the position they are taking. This position they are taking is so inconsistent with their own historical claims. But you see, this is Ghana. Some people, because of the excesses of the tribunals set up by the Rawlings regime, anytime they hear tribunal, they see red flags. Okay? You see the bull. I'm sure you've watched bullfights and so on. As soon as you wave a red flag, it doesn't matter the size of the flag. It doesn't matter the quality of the cloth. It must just be a red flag.
Or the location.
It doesn't even matter the location. Nothing matters. The most important thing is the color of the flag. If you wave the red flag, the bull will come attacking. That is what we are seeing now. We are in a bullfight. They have seen tribunal. Tribunal, hey, they have to headbutt, they have to fight. It doesn't matter who constitutes the tribunal. It doesn't matter the laws governing the tribunal. Nothing matters. Location doesn't matter. Quality of cloth doesn't matter. Nothing matters. It is red cloth. Let's attack. That is what is happening. And the thing which intrigues me is that I think some of them actually know what they are doing. They assume that the people of Ghana are so gullible. In fact, sometimes they're not just dealing with gullibility. They actually think that we are so stupid that the moment tribunal is mentioned, we will headbutt like bulls in the ring fighting. This is insulting to us. Because we are not bulls seeing red flags. We are humans. Reasonable humans capable of thinking. Yes, we see a red flag, but we want to know the quality of the fabric. Perhaps even the manufacturers are different. You understand? Perhaps the size of the fabric is different and so on. So we go beyond the color. We are not bulls in a bullfight. And that's what they must recognize. Master, let's go forward and not waste our time anymore. This is the third time I'm discussing this topic this week. Why? With all that is happening around the world, with Donald Trump behaving in Iran, with the European economy tumbling down, with xenophobia in South Africa, and all of that. We are discussing this topic 3 times in 1 week. Ebe, Abba, why?
To be very frank, I haven't heard you all week. So I didn't know how you were going to, but it's always interesting to hear you speak about, take every issue, not on its face value, but look at it objectively. And I appreciate that because we know your own experiences with this kind of things. But it's nice to
I
always hear
was tried by the National Public Tribunal. I was tried by the National Public Tribunal. You understand? When I was tried before the National Public Tribunal, former President J.A. Kufuor volunteered to be my lawyer. Okay. I knew the tribunal system. I knew they were not going to talk law. So I told him no, I would not accept. I told President Kufuor not to be my lawyer. I decided to defend myself. And I told the tribunal that we are not coming to talk law here. We are coming to talk politics. And therefore, I'm my own best defender. If you see the photographs of my trial before the National Public Tribunal, you will see that President Kufuor sat behind me. In fact, what President Kufuor did for me was to take down notes and to draw my attention to some points of law and so on. But I defended myself before the National Public Tribunal because I refused to accept that it was a legally constituted, adjudicator which was going to deal on the basis of law and so on. So as for criticisms of the public tribunal system as existed under Rawlings, I uphold them. Those were kangaroo courts. Those were monstrous courts. But those are not the courts that the 1992 Constitution seeks to establish.
Thank you. Thank you very much. And before we move, when we're reading the qualification, what qualifies someone to be a member of the tribunal, I went back to read even the members, about the high moral character, to read a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity. Is the very first thing they talk about before talking about the 15 years as a lawyer, among others. So I think they are considering virtually the same things, just that they are making room for people.
Tribunals, like I'm saying, even if we have some specialized ones, you can understand. That's the kind of thing I would like to see. Just to expedite justice for all of us. And you must also understand that, especially in the case where some people are afraid that if there's tribunal, maybe they are the first people to go because maybe they have some cases. Then actually they need to do complain.
Well, like I was saying, okay, so I still have some books. These books I have already given away. I don't know why I'm keeping things that I've given away. But I'm still keeping about 7 books. Komla Ganya has promised that he'll come and pick his up today after the show. I'm sure he'll be around soon. But I still have Angelo Kojofi Agbe. You have a book here that you're supposed to pick up. The Nkrumah book, The Reparation. There's Eriko Kusepenu, who's sending comments to me. You promised to send your one of your family members to pick them up on your behalf because you're not in Ghana. There's Musa Batwa, Prince Duzo, Eriko Konu. There is Lawrence Chow, all of you. So please, this is and I'll announce this again.
Don't we have time to do any other thing? Why have we spent so much time and energy discussing something which is so very clear and so very simple to understand? It shocks me. Now listen, I speak as somebody who was put on trial before the National Public Tribunal. I was on trial before the National Public Tribunal. I had been charged together with Professor Edubuaini. We were tried by the National Public Tribunal, and I know what I'm talking about. You see, in one of the conversations that I had on the public tribunal, the establishment of public tribunals, I simply urge those who are listening to us to take any dictionary in the world and look up the word tribunal. Now, that should settle the matter, because a tribunal is another word for court. So instead of calling it regional tribunals, the Constitution could simply have said, let us establish regional courts. Would that have ended this needless, fruitless debate? Sometimes I just wonder. I know those who are steering up this discussion, this debate as well. They are lawyers. They are leading parliamentarians. They are high-ranking political office holders, including a former vice president. I can't believe it. Master, I simply can't believe it. Sometimes they talk about the history of tribunals, and they start from the mid-1980s. That's where they start from. Whoa. Is that how their sense of history is limited? Because if you're going to talk about the history of tribunals, tribunals have a history of more than 500 years. So if you want to talk about the history of tribunals, let's go there. Tribunals were actually first established in Rome. And tribunals in Rome, the word tribunal is actually derived from platforms, days. In those days, people who gave judgment, judges and so on, sat on a dais, a platform. It is that platform which was called tribunal. And over the years, that platform, the name of that platform, came to represent the institution of justice. You understand what I'm saying? So originally, a tribunal is a platform on which judges sat. And then over the years, it came to represent the institution of justice. But you see, tribunal originally was not even English. Tribunal originally was not French. Tribunal came to be adopted as an English language expression, meaning court, in the 1400s, between the 1400s and 1500s. That's when the word tribunal was adopted into English and into French. You understand? Now it's important also to understand that tribunals were established in Rome to protect the weak, the poor, and the vulnerable from the Senate and from the high-handedness of elite courts. This is part of the history of tribunals. Okay? Now, Sana, no doubt, in Ghana, if you're looking at the history of tribunals and you start from the 1980s, you will be worried. Because the Rawlings regime actually abused the concept of tribunals. No doubt at all about it. Tribunals were populated deliberately by loyalists to the regime. And persons who were tried before the tribunals had no right of appeal, which was an abuse of their fundamental rights and so on. This is the 1980s. But the tribunals we're talking about now are not the tribunals of the 1980s. And only lazy people who refuse to read, who refuse to understand the text of the 1992 Constitution can engage in this childish populist play that we are seeing. It's amazing. Now, all of us, there's nobody who has stood up publicly and said that the 1992 Constitution should be violated. Whether they are in the NPP, CPP, NDC, or UP, everybody is saying that the 1992 Constitution should be respected. I've not heard anybody who says that we should only respect portions of the 1992 Constitution and not respect other portions of the 1992 Constitutions. Indeed, when President John Dramani Mahama took the oath of office, he swore to protect the Constitution, the 1992 Constitution. Not parts of the Constitution, but the whole of the Constitution. So today, when I hear people saying that there are some things in the Constitution which we should ignore or not implement or which we should violate, I wonder how that is consistent with their commitment to protecting the 1992 Constitution. I just wonder. And you see, Senna, I have before me the 1992 Constitution. This is the 1992 Constitution. Now, in Article 142 of the 19th Constitution, headed regional tribunals, it is clear that the Constitution enjoins us to establish regional tribunals. Now I'll read the provisions. This is Article 142, subsection 1. There shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. It's a constitutional provision. You cannot go against this if you want to uphold the 1992 Constitution. It says the Chief Justice must establish regional tribunals. 2. A regional tribunal shall consist of A, the Chief Justice, one chairman, and such other members who may or may not be lawyers as shall be designated by the Chief Justice to sit as panel members of a regional tribunal, and for such period as shall be specified in writing by the Chief Justice. This is also a constitutional provision. 3. A regional tribunal shall be duly constituted by a panel consisting of the chairman and not less than 2 other panel members. 4. A person shall not be appointed to be chairman of a regional tribunal unless he is qualified to be appointed as a justice of the High Court. It is in the 1992 Constitution. 5. A panel member of a regional tribunal shall be a person of high moral character and proven integrity. This is the 1992 Constitution. So this is the 1992 Constitution. And we are being told that we should throw it away. We are being told that we should throw it away simply because the Rawlings government established courts which violated the rights of citizens. Now, Senator, so if the Rawlings government had not established tribunals and had established courts, would we be arguing today that Ghana should never have courts? If you come to consider the fact that the tribunal is just another word for court, and the Rawlings government had decided to establish courts instead of tribunals, would we be arguing today that there should be no courts in Ghana? What is this? And for me,